Hi, my name is Alex Dolphin, and welcome back to another episode of Ex Ante. Today we're going to discuss the case United Foods versus Zuckerberg. This case was heard in the Delaware Supreme Court in the year 2021. Let's go ahead and jump into the facts of the case. So United Foods, they are stockholders of Facebook stock. They own Facebook stock, and they are suing. This is a derivative lawsuit. They are alleging an indirect harm in the name of Facebook, the corporation, and they're suing the board of directors. So Zuckerberg, Mark Zuckerberg, a man that we all probably have heard the name of before, the founder of Facebook and the chairman of its board. There are also 8 other board members that are named in the lawsuit. So what's the story behind this lawsuit? Well, it started when Mark Zuckerberg decided that he wanted to join in on the Giving Pledge. This is a pledge headed by ultra-wealthy individuals like Bill Gates and Warren Buffett, where they try and give away all of their wealth through philanthropy. It's a really admirable goal to give away money, I think, and we can all look at it that way. The problem for Mark Zuckerberg is he didn't have a lot of cash on his balance sheet, so to speak. What he does have is a lot of Facebook stock. That Facebook stock is ultra valuable, billions and billions of dollars. So, potentially he could sell that stock and give that money away to individuals and participate in this giving pledge. Now, one problem for Mark Zuckerberg is he wants to retain control of Facebook. Now, what happens with stockholder ownership is you get votes in corporations. So if Mark Zuckerberg is to give away all of his shares, then he's going to lose all of his control of Facebook. And Mark Zuckerberg, I'm assuming, kind of looks at Facebook like his little baby, as his little brainchild. He doesn't want to give up control of that. And so he is trying to think of a way where he could give away his stock, give away his wealth, but retain control. And so the device that he basically comes up with, and Facebook's legal team, is a stock reclassification. What this would do is this would, realign the voting rights in Facebook stock so that Mark Zuckerberg would be able to sell off a mass chunk of his stock and still retain voting control and majority stakeholder control in the owner or in the company. So that's essentially what he is trying to do. Now, that whole process goes awry. As you can imagine, the minority shareholders in Facebook don't like the idea of Mark Zuckerberg basically, selling a bunch of stock and then keeping control. They don't like the idea of a reclass. It essentially can, kind of wash out their voting rights if this happens. And so they don't want that. So they bring a lawsuit against Mark Zuckerberg there. And in that lawsuit, they're saying, hey, you can't do this reclassification. Long story short, that goes on for a while. Eventually, Facebook says, you know what, this is just complete bogus. We're done fighting this. Go ahead. Go ahead, stockholders. We're not going to do this. We will, settle this claim out. Let's just be done with this. And so they settled that claim out, and they paid a lot of attorney's fees in defending it. And it was $80 million, right? And that reclass, like I said, never went through. But $80 million went out of the corporation's coffers and into the pockets of the attorneys and the other side. And so now these plaintiffs, United Foods, are saying that was wrong. You should not have done that. That was a big problem. You were acting in bad faith when you did that. When you spent that money, it was not loyal to the corporation. And so we're going to file a new lawsuit. And so this lawsuit is just at its infancy. It is just trying to get past the demand requirement. What the demand requirement is it's under Delaware law. You have to make a demand upon the board before you can file a derivative lawsuit. Or if you don't make that demand, you can plead and say that demand would be futile, meaning that there is no point for me to make a demand on the board because they're not going to sue themselves. They're acting in bad faith, and they haven't acted, with their fiduciary, in accord with their fiduciary duties. And so, hey, there's no reason for us to make the demand on board. It would be futile, essentially. And so that's what the plaintiffs in this case are trying to do. They're saying, Facebook, run by Mark Zuckerberg, and they're all in bed with Mark Zuckerberg. They're all great friends. They were all, in cahoots here. There's no reason for us that we should have had to make a demand. It would have been futile. And so Facebook is saying, no, that demand would not have been futile. And so they're essentially filing a motion to dismiss, saying, you can't file this derivative lawsuit unless you make a demand upon the board. And so this lawsuit is dealing with the demand-futility requirement. Essentially, what does a plaintiff need to plead to prove that demand would have been futile so that they can move forward in the lawsuit? Now, the first issue in this lawsuit, and it's in the wake of Aronson v. Lewis, the old test, I want to say. This is an abrogation of the Aronson test, where we're saying, can we say that a breach of the duty of care through gross negligence, can you plead that to say that demand would be futile? And the court says no. And the court in the past kind of seemed to say yes, like that would be fine. But the court says here the answer would be no, because Facebook has a 102(b)(7) exculpation clause in their charter. Okay, so let's unpack that a little bit. That means that Facebook's board cannot be liable for gross negligence. They can only be liable for a breach of duty of loyalty, breach of a duty of good faith, not a breach of a duty of care. So you can't say that demand would be futile because the board of directors breached their duty of care, because they would not be liable in that sense. So essentially that's the first question the court says is, you know what, that doesn't matter. Okay, if they have an exculpation clause, you cannot say that demand would be futile by saying that the board breached their duty of care. So that's one. Two, they say, you know what, this Aronson test, it's just not really up to snuff. It was an old test and we just need to reform it. They're saying we're not going to overrule the Aronson test, but we're just going to give you a new one. So essentially they kind of are, but they're saying expressly, this is in accordance with our old law. And so what's the new test for demand futility? Well, you have to plead for a majority of the board a majority of the directors that were on the board at the time of the alleged breach, that demand would be futile because, one, those board members received the material benefit from the alleged breach. Okay, so that's number one. Two, those board members face substantial likelihood of liability because of the alleged breach. Or three, those board members lack independence from one of the board members who received a substantial material benefit from the alleged breach of fiduciary duty. So it's a three-prong analysis. And if any of those, if there's an answer to one of those three is yes, for a majority of the board, then demand would be futile. So that's the new test. There's three questions. If one of them is yes, for a majority of the board at the time of the alleged breach, then demand would be futile and it is excused, and you do not have to make a demand on the board to bring a derivative lawsuit. So it's kind of a new test where we're just saying, you know what, in all practical instances, that second prong where the directors would face substantial liability, that's not going to apply in a duty of care case, because basically all corporations have an exculpation clause that says directors are not liable for a breach of the duty of care. So this is just kind of to refine and say, in instances of breach of loyalty, a breach of duty of good faith, this is how we would prove that demand is futile. So how does that analysis look here? Well, they say that there's, first off, two of the members of the board, the current board, were not members at the time of the alleged breach. So we just dispatch of them quickly. And then we look at the rest of the board. And there are a few that the court says right off the bat. Mark Zuckerberg is the first one. And then Mark Andreessen, who is really good friends with Mark Zuckerberg, and they're texting back and forth about this reclassification. They say that guy's not independent either. And then the COO, so an employee of Facebook who's on the board, they say she is also not independent. And so they look at the analysis of the other stockholders and they say, did they receive a material benefit from this transaction? No. From this alleged reclass? No, they did not. Did they face any substantial likelihood of liability? No, they did not, because Facebook has an exculpation clause. There's nothing that looks like this was self-dealing here. So no, they didn't face substantial likelihood of liability. And then three, did they lack independence from Mark Zuckerberg, essentially? And that's where Mark Andreessen gets kicked out. But the rest of the board, they say, the plaintiffs didn't make a good enough argument that these board members lacked independence from Mark Zuckerberg. And for that reason, demand is not excused here. And they say, just this kind of, the plaintiffs pled that there was a friendship between Mark Zuckerberg and these other members of the board. And just that simple friendship alone is not enough to say that they lack independence. Board members are naturally going to be friends. That's not lacking independence. The court doesn't exactly say what would, what lacking independence would look like perfectly in this scenario. But they say just a friendship is not enough. And then also, Reed Hastings, Peter Thiel, both apparently the plaintiffs said had a, propensity for looking at companies that are led by their founders. And because of that, they lacked independence. They say, no, that's just their characteristics. That's just the way they look at the world, and that's why they're on the board. And so essentially Facebook is off the hook here. The board of directors is off the hook. And so that's the new ruling. It's an abrogation of Aronson. It's just interesting to think about. essentially this test and the third prong, lacking independence, that is kind of a broad term. And I could think of another world where a court, if it weren't as business friendly as some of the courts are in Delaware, would say that these good friends of Facebook and Mark Zuckerberg have been on the board for years. Maybe they don't lack. Maybe they do lack independence from Mark Zuckerberg, right? They've done plenty of business deals before. They've been in boardrooms forever. When you're just spending time around people, you become friends and you kind of want to do them a solid, right? And they scratch your back, you scratch their back. Yes, there's not something that's super concrete, but I think, could we say that someone who's been on a board with Mark Zuckerberg for years and years and has basically gotten this great position from Mark Zuckerberg on Facebook, board of Facebook, which is a very powerful position, can we really say that that person is independent from Mark Zuckerberg? And I think in the court's interpretation, yeah, we can when we interpret independence very loosely. But if we look at independence in another light, we might be able to say that, these board members they're not really independent of Mark Zuckerberg. And so it's interesting, this is where you see Delaware's stripes coming out. It is a pro-business state. And you know what? These board members, they are elected by the stockholders. And that is essentially the primary aspect of control. They say that, when the stockholders elect these board members, guess what? You are delegating your duty to them. And if you think that, Mark Andreessen and Mark Zuckerberg are great friends, then maybe you just should get Andreessen off the board, and put someone new in there who's not great friends. And this is kind of emphasizing that importance of voting. Now, it's also really easy to say that in a typical corporation. It's not as easy to say that in a corporation where Mr. Zuckerberg has majority control and basically controls everything. And this is a public company like Facebook that, some people would say controls the world and runs the world. And you can see just how, you have these tensions in corporate law, and where you can see how people might look at this at a different angle if this were in a different state. But it is a very interesting case, and it's nice to see a clear standard for demand futility going forward. So thanks so much for watching this video. I hope you enjoyed it. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.